Hello, welcome to Gwungmijana's legal discourse on Law of Evidence 2 series. That is second semester Law of Evidence, Pool 411. I think so. Pool 411. So first semester is a Pool 401 here in Nigeria. Then second semester is Pool 411. Today's concern is on the second semester. Please, before I proceed to the main gist for today, if this is your first time, or even if it is not, but you have not subscribed, please do so. That's what keeps it going. Do well to subscribe, like, share, and comment. So in today's video on Law of Evidence 2, I want to discuss, the topic for discussion is character evidence. That's the topic for today. Character evidence is one of the topic for second semester according to our course synopsis or outline. Character evidence. So your goal or the objective of this study is, at the end you should be able to know what is character evidence, and is character evidence admissible generally, and also when is character evidence admissible in civil and criminal proceedings, and also why do parties deploy or make use of character evidence. That is essentially what this topic is concerned with. So let's go. The first point, the first heading is, what is character evidence? Character evidence is simply evidence of a person's character. Giving evidence of a person's character. When you give evidence about a person's character, that is character evidence. Giving evidence of a person's character in order to prove your case, relying on the character of a person, or giving evidence of a person's character to support in a bid to prove your case. You decided to give evidence of, it could be evidence of your character or evidence of the character of your adverse party or the witnesses. That's character evidence. So the operative word here is now character. The next question is, what is character? Well, that's the main concern of the topic. What is character? Now, before I do that, I would love to mention the relevant section of the Evidence Act for this study. The relevant section of the Evidence Act for this study is sections 77 to sections 77 to section 82 of the Evidence Act 2011, and section 180, specifically paragraph G and subparagraph I to III of that paragraph G. So paragraph G, I to III, that is to 3 of subparagraph G of section 180. Those are the major sections. There are still other relevant sections, but those are the major ones. So let's begin. What is character? Well, character is just, for instance, literally, character is just somebody's traits, somebody's qualities, somebody's moral standing. So it is somebody's traits or quality that distinguish the person from others. But in law, the general definition or the common usage of a word may not be relevant in law or may not be so. So, more appropriately, what is character evidence? What is character, rather? In fact, we don't need to go about the houses looking for the definition of character. We don't need to beat about the bush or wander in the wilderness, because interestingly, the Evidence Act actually define the word character. So fortunately, the Evidence Act define it for us. Unlike there are some other topics you will treat the relevant word you cannot even find, because the interpretation sections only define some words. So there are some topics you will look at, you find a relevant word, you cannot even find the meaning in the Evidence Act. But fortunately, this one, character, had been defined for us. So let's rely on the Evidence Act, which is our principal authority with respect to discuss. So, how does the Evidence Act defines character? Character is defined in section 77 of the Evidence Act. Thus, section 77 of the Evidence Act is the section that defines the word character. And how does it define it? Let's hear from the horse's mouth. So it defines character. It stated that character in section 88, in section 78 rather to section 82, sections 78, that character in sections 78 to section 82, that the expression character in section 78 to 82 means reputation as distinguished from disposition. That the expression character means reputation as distinguished from disposition, and except as mentioned in those sections, evidence may be given only of general reputation and not of particular acts by which reputation or disposition is shown. So that's the definition of character provided in section 77 of the Evidence Act. And it defines character. It actually restricts the definition of character to certain sections. That the definition of character in section 78 to 82. So whenever you are making reference to section 78 to 82, that's what character means. But it's not limited to that section. Actually, anytime character in civil proceedings is being mentioned or is relevant, it is actually this definition given here that is adopted, that is used. So despite that the Evidence Act said that character in section 78 to 82, the expression of character means it is not limited to only that section. Anytime the expression of character comes in, it is usually the meaning here. So what is the meaning according to this section 77? It said that character means reputation. So let's attempt some analysis of that section. That character means reputation. It means reputation. And when you see the word means, is opposite to includes, which means that the list is not exhausted when include is used. But this one says means, meaning that it means what is stated here and nothing else. So character means reputation as distinguished. This section now is also distinguishing character from disposition. And what is disposition? Disposition is the tendency to act in a particular way. So disposition is defined as the tendency. If you have the tendency to act in a particular way, so you might be inclined, you might tend to act in a particular way, but that does not show your character according to this section. So if you just act in a particular way, in a particular matter, that does not show your character generally according to this provision. So this provision now is distinguishing disposition from reputation, which is character, because character and reputation, yeah, they are the same thing. However, it has been observed that under English Criminal Evidence Acts, that character has been held to mean both reputation and disposition, and that was in the case of slavery versus against DPP, where the court held that character under English law means both reputation and disposition. So you can see that the definition of character under the English Criminal Evidence Act is somewhat wider, but it includes both disposition. So if you tend to act in a particular way in a particular circumstance, it also constitutes your character. It can be adjudged as your character. Then another thing the section stated is that evidence may be given only of general reputation and not of particular acts by which reputation or disposition is shown. So the only evidence allowed is evidence of a person's character, which is someone's general reputation. So it's evidence of general reputation and not disposition, which has to do with one particular act you do. So one particular act cannot be used to adjudge your character. However, it does not mean that evidence of a person's disposition cannot be given, because the section says except as mentioned in those sections. So except as mentioned in those in section 78 to 82, meaning that under section 78 to 82, evidence of someone's disposition too can also be given. So in appropriate circumstance, under section 78 to 82, evidence of both disposition and reputation, which is character, can be given. That's how best the provision can be interpreted. But what is important is that character means reputation, and it is general reputation. Now, what is reputation? Reputation, according to the Black's Law Dictionary, is the esteem in which a person is held. The esteem in which a person is held. So, in what esteem is a person held? The esteem in which you are held is your reputation. How other people estimate you. How do other people see you? How do they estimate you? How do they regard you? That is your reputation. So it means that the measurement of your reputation now is actually other people estimation of who you are. That is your reputation. So the barometer for measuring a person's reputation is actually other people's view, other people esteem of you, how people estimate you. That is your reputation. And the reputation, people estimation of you can be good or bad. That's when you have good or bad character. So now character can be either good or bad. So the type of character here is bad or good character. So as we shall discuss, we may be mentioning either good, talking about either good or bad character. So a person can be of good or bad character, and it is based on people's estimation, people's assessments of that particular person. So that's that's the meaning of character. Now let's proceed. The next question is, Is character evidence admissible in judicial proceedings? Is it admissible to give evidence of a person's character in a case when you want to prove your case, instead of you to prove the elements of if it is an offense, the element of the offense, or even in civil cases, if it is a particular thought, instead of you to prove the element of that thought, you are now talking about a person's character. Is it admissible? Well, as humans, sometimes the thought of the law is usually different from our own thought. As humans, we may wish that character evidence of a person's character should be admissible, in the sense that, if a person is of good character, then it will be less likely that he did not commit the offense or commit the civil wrong, or if it's of bad character, he committed it. But that may not usually be the case. That's why the law has developed some rules to determine when and to what extent character evidence can be admissible. So the question, is character evidence admissible? The question cannot actually be answered appropriately, straightforward. Generally, a general answer may not be given. It may not be easy to give a straightforward general answer, but I can say that generally the character evidence of a defendant bad character is generally inadmissible, but evidence of a defendant good character is admissible. So evidence of bad character is inadmissible, evidence of good character is admissible generally. But that is not more very appropriate. The question can be best answered when it is related to civil and criminal proceedings, civil and criminal cases, civil and criminal trials. So we shall look at the question whether character evidence is admissible in civil cases and in criminal cases. So we shall now look at it under two heading: civil cases and criminal cases. That's how we shall consider it, because the rule varies. The rule that determines the admissibility of character evidence varies from civil to criminal cases. The rule in criminal and civil cases, they vary, they are different, although there may be some similarity. So let's look at it under that heading. First, is character evidence admissible in civil cases, in civil proceedings, in civil trials, whichever one you may wish to call, where you have the plaintiff and the defendants, or the claimant and the defendant. Those are the parties in a civil case. So the question now is character evidence admissible in civil cases? Well, we shall not wonder looking for the answer, because the answer has been statutorily provided. The Evidence Act had also helped us, had made this matter very easy for us by providing the answer for us in section 78 of the Evidence Act. So let's hear from the horse's mouth as to admissibility of character evidence in civil proceedings. It states, in civil cases, evidence of the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is, this is the operative word, inadmissible. If the section had ended there, the matter would have also end ended there, the matter that would have been the end of the matter, and it would have been simple, straightforward answer. But the section did not end there. The section further provide for exception, a proviso. He used an operative word, a proviso word, which is except insofar as such character appears from the facts otherwise relevant. So this section provides for general rule and the exception. So in civil proceeding, by virtue of section 78, forget the long sentence. The answer is that in civil proceeding, generally, character evidence of the party's character, whether of the plaintiff or whether of the defendant, or whether it is of good or bad character, is generally inadmissible, except evidence of the person's or character is relevant in view of the fact of the case. Except from the fact of the case, evidence of the person's character becomes relevant. That's when it will be admissible. In fact, you must also take your mind to relevancy when you are talking about character evidence, because it is character evidence that it is relevancy generally that determines admissibility. Is it relevant? So generally in civil proceeding, character evidence is irrelevant and inadmissible, except it appears evidence of the character of a person concerned becomes relevant from the facts of the case. It will be relevant to give evidence of the person's character. So that's the answer as provided in section 78. Now the next question is, in what circumstance now can the evidence of a person's character becomes relevant so as to make it admissible? When does the evidence of a person's character becomes irrelevant? Now, there are some examples of cases where evidence of character evidence in civil proceedings becomes relevant. There are some cases, there are some circumstances when it will be relevant, and those are the exception. Those cases where evidence of a person's character or character evidence will become relevant from the facts are the exception to the rule. So there are some examples of exception to this general rule. So let's look at the exceptions to the general rule. Let's proceed to look at the exceptions to the rule that character evidence is inadmissible except it becomes relevant. What are the exceptions to the general rule? There are 3 exceptions we are to discuss. So the first can be tagged as defamation cases. The second is action for breach of promise to marry, and the third is in assessment of damages. Those are the 3 cases where character evidence in civil cases can be admissible. So let's look at them briefly, one after the other. The first is in defamation cases. In defamation cases, so character evidence becomes relevant in an action for defamation. Defamation is an injury to a person's character. When you injure a person's character, a person's reputation, is an injury to reputation. So any person bringing an action for defamation is complaining that you have injured, you have injured his reputation, the esteem with which people held him. You have reduced him before members of the public, the society, before those who knows him. You are lower his esteem, discredit him. So since defamation is an action to protect reputation, which is a person's character, It means that a person bringing an action for defamation is actually claiming that it's of good character. Therefore, he has put his character in issue. By putting his character in issue, his character thereby becomes relevant in that case. His character becomes relevant in that regard by claiming to be a person of good character whose character need to be protected by the law. He has put his character in issue and it becomes relevant, so evidence of his character can actually be given. More properly, the point and the law is this: in an action for defamation, whenever the plaintiff, whenever the defendant rather pleads what is referred to as justification. Justification is one of the defenses to defamation action. One of the defenses the defendant can raise or rely upon. And justification, you are saying that what you state is actually true, is correct. So whenever a defendant pleads justification, is entitled to give evidence of the bad character of the plaintiff in order to substantiate its claim. Or a defendant who pleads justification can also give evidence of the plaintiff's bad character in order to mitigate the damages that the plaintiff will be entitled if maybe the defendant is still found liable. And this has statutory backup. This exception has statutory vituperations, statutory backbone, by virtue there is a section 80 of the Evidence Act contained this exception. So if an action for defamation by God bring an action of defamation against Long, and Long pleads the defense of justification, that what is stated about God is true, Long is entitled to give evidence of the bad character of God. Also, even where the action may be declared in favor of God, that there is defamation, Long is still entitled to give evidence of the bad character of God in order to mitigate the damages which will be awarded together with the law as contained in section 80. So if you see section 80 of the Evidence Act, if you are to read this section here, you will not understand, because this section is a kind of a cumbersome, and the couching, how the section is couched, it may not be easy to decipher the meaning by reading the section from the word used there, but there's the interpretation. The interpretation is that where a person pleads justification, is entitled to give evidence of the plaintiff's bad character. Also, he can also give evidence of the plaintiff's bad character in order to mitigate damages. So the section now also made it clear that if you do not plead justification, you cannot give evidence of the plaintiff's bad character. So the condition for you to give evidence of the plaintiff's bad character for the purpose of mitigating damages or substantiating your claim is if you plead justification. However, if you do not plead justification, you can only do that with the leave of the judge, under two circumstances. One, either with the leave of the judge, or you can do that if before the trial you furnishes the particulars to the plaintiff of matters as to which you intend to plead. So you give the plaintiff the particulars of the matters about his character which you intend to plead in order to mitigate damages or substantiate your claim. So that's what section 80 is saying, of which the mere reading of it may be difficult to understand, but there's the purport of the provision. So the crux of this heading is that in action for defamation, a defendant can give evidence of the plaintiff's bad character. One common and illustrative case is the case of Dean versus African Newspapers Limited. So the case of Dean versus African Newspaper Limited, the court upheld the fact that a person who brings an action for defamation has put his character in issue, and that the defendant is entitled to give evidence of the person's bad character in order to refute the person's claim of having a reputation. That case now, the plaintiff was actually a retired military officer, and he attempted to contest for an election and was rejected by the electoral body. And one of the reasons was cited was because of so one of the reasons for rejecting the plaintiff that wanted to contest for an election in this particular case was for his previous conviction. Now the plaintiff held a news conference where he claimed that he served the Nigerian army, he served the army meritoriously without any spots, without any blemish. You can see how the plaintiff is eulogizing himself, giving himself a good reputation. So the army was infuriated, incensed with this false claim by the plaintiff. The army now decided to hold their own press conference, also press briefing, also in order to refute the plaintiff unmerited reputation, the plaintiff claim. And the army did. In that press conference or briefing, the army published a notice about the circumstances in which this said plaintiff was dismissed from the Nigerian army, and also they also instruct the public not to address him as a captain that is not even entitled to be addressed as a captain again. So this notice was the defendant, a news agency. They were in that press conference, and they also received the notice which was given by the Nigerian army, which they publish in their medium. Now it is because of this that the plaintiff brought the action against them. So in the pleadings, they joined issue as to his previous convictions and character. The court held that since the plaintiff has claimed to have a reputation, that he has put his reputation in issue, it has become a relevant fact for which evidence can be given, that the defendant is entitled to give evidence of the plaintiff's bad character and also proof of his previous conviction. So the court affirmed this principle that in defamation cases, the defendant can give evidence of the plaintiff's bad character. Another case example or exception is action for breach of promise to marry. In an action for breach of promise to marry also, the defendant is also somehow protected. So where a person proceed against the defendant, bring an action against the defendant for breach of promise to marry, this will usually be a woman, for breach of promise to marry, that the defendant promised to marry but breached the promise, failed. Now, from decided cases, the defendant is entitled to give evidence of the plaintiff's bad character as the reason for his breach of the promise. So he can give evidence of the plaintiff's bad character as the justification of his repudiation of the promise to marry. That why he breached the promise was because of the plaintiff's bad character. Maybe the plaintiff is a wrong girl. It's a kite that he did not want such person again. So he can give evidence of the plaintiff's bad character as the reason for repudiation or breach of the promise. So in that case, evidence of bad character is admissible. So that's one of the circumstances in which character evidence is admissible. Another circumstance, which is the last exception here, is in assessment of damages. In assessment of damages, and this also has a statutory provision. It is provided in section 79 of the Evidence Act. Take note that in the case of breach of promise to marry, there's a case there, Jones versus Jones, that character evidence was given, but I was not able to find the fact of that case, Jones versus Jones. Then another one is assessment of damages. So character evidence is relevant in determining the amount of damages which a person is to be awarded or is to receive, and this is provided or embedded in section 79 of the Evidence Act, which states, notwithstanding section 78, because section 78 provides for the general rule that character evidence is inadmissible, and section 79 is saying, notwithstanding section 78, in civil cases, recall we are talking about civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive may be given in evidence. So notwithstanding the general rule in section 78, section 79 is saying that in civil cases, the fact that the character of any person is such that if the character of any person is such that will affect the amount of damages the person will be awarded, will be entitled to, may be given in it. So evidence of character of a person who ordinarily should be entitled to damages in a given case can be given. So the defendant can give evidence of the plaintiff's character so as to affect the amount of damages to be awarded to the plaintiff. So in this case now, evidence of character can be given to, it can either be given to aggravate or mitigate damages. It can be given to reduce or increase the amount of damages a person is to be given. For instance, if it is the plaintiff that is given evidence of his good character, so that can lead the court to increase the damages. But if it is the defendant now giving evidence of the bad character of the plaintiff, that can reduce the damages. But what this section is saying that evidence of a person's character can be given to affect the damages which the person ought to receive. So it is properly the plaintiff in this case. So evidence of the plaintiff character can be given so that it will affect the quantum, the amount of damages that is to be awarded in a given case. So there's the exception. But there's something that's clear from the beginning as to the basis of the general rule that character evidence is inadmissible. There's a rationale for that rule. The basis of that rule has been stated by the court. So the court has stated the basis or the rationale, reason why generally character evidence is inadmissible in civil proceeding. The court stated that in the case of A.G. Bowman and A.G. Radloff. So the court stated the basis of inadmissibility of character evidence in civil cases. That's where the court stated the rationale for that rule. And the court stated thus: in civil cases, no presumption would fairly arise in the very great proportion, that's in most cases of such cases, in the very great proportion of such cases, from good or bad character or the defendant, that he did or did not commit the breach of the civil duty alleged against him. So what the court is saying in that case is that in civil case, it cannot be fairly presumed. You cannot fairly presume that the defendant might have committed the civil wrong, the breach of the civil wrong alleged against him from his character. You cannot actually use his character to make that presumption. It cannot be fairly presumed. Character cannot be used to determine in civil cases. That's what the court stated in that particular case. It cannot be presumed from the person's character. For instance, in an action for trespass to land, you cannot actually use the person's character to now determine, did he trespass on the land from his character? Can you use the person, he has a good character? That cannot reasonably suggests that he did not trespass on the land because he has a good character. So there's in civil case, it will not be fair to presume based on character. That's what the court is saying. So we have to end it here so that it should not be too long. Then continue the discussion in respect to character evidence in criminal proceeding in another video. Thank you. And don't forget to subscribe, share, like, and comment. Share so that other people can also benefit.